All property rights are a result of scarcity. You must grasp this before proceeding any further. Any definition of a property right can be reduced to a just ability to use a good, and libertarians believe that if such a use is not being conflicted with, then you are not a victim. This is where ethical problems with intellectual property, such as copyrights, patents and trademarks, begin. If I use an idea that was first conceived by you, you can still use the idea. If you make a more efficient engine and I copy the engine design with my materials, your engine will still work. If you make a film and I pirate it, your copy has been entirely unmolested by my actions. Evidently, there is no conflict over the uses of ideas, with one use not interfering with another, and thus no need to assign property rights. So since uses of ideas cannot conflict, what precisely do IP laws criminalise? In order to stop someone from using an idea, one must restrict what people are allowed to do with what would otherwise be their own property. The only way to stop me from copying an engine which you made would be to penalise arranging materials in that manner. Optical discs and flash memory drives must be banned from having a certain pattern of binary digits. Clearly, IP must therefore attribute a degree of property rights over every useful material for copying the idea to the inventor or author. But this undercuts the libertarian position on property rights, that if you are not the first user of the good, then you cannot possibly be the just winner in a conflict over the good. And so, despite authors and inventors being the first users of ideas, they cannot win a conflict over the use of them due to the impossibility of such an affair, and owing to the implausibility of being the first user of every actually scarce good useful for realising those ideas, they cannot be winners in those conflicts either. Some libertarians would beg to differ. Ayn Rand, for example, held that patents and copyrights are the legal implementation of the base of all property rights, a man's right to the product of his mind. Production, however, is not a source of ownership. It is indeed a source of wealth, but the only way to become the owner of something is to homestead it or trade it. Production is merely changing already owned materials into something more valuable. Rand, however, adds a proviso that a discovery cannot be patented, only an invention, primarily on the grounds that the discoverer did not create the law of nature identified. This doesn't take into account that the inventor doesn't really create anything either. He didn't create the facts of nature exploited to make the invention work, nor did he create the materials the invention was made out of, nor can it be denied that similar mental effort is required to formulate both inventions and discoveries, so this distinction is also arbitrary. Further capriciousness also stems from Rand's belief that intellectual property is not perpetual. How can anyone seriously maintain that 19 years or 21 years for a patent is too short or long, any more than saying X or Y is too low or high for a gallon of milk in an unhampered market? In attempting to answer these questions, some have adopted utterly absurd theories on IP, most notably Andrew Joseph Galambos. Galambos thought that property was two parts. First and foremost, a man's life, and secondly, all non-procreative derivatives thereof. Life consisted of ideas and actions, and since non-procreative derivatives are just that, derivatives of ideas and actions, property over ideas were superior to actual property. He henceforth claimed the property rights to these claims, banned students from repeating them, changed his name from Joseph Andrew Galambos to not infringe his father's rights to that name, and dropped a nickel in a fund box every time he said liberty to compensate the relatives of Thomas Paine, who apparently invented the term. It is a result of the inherent aggression and absurdity caused by IP that libertarians only support contractual arrangements to protect ideas. For example, an author can make a buyer sign a contract before selling the book to him, transferring damages to the author if the buyer copied the book without his permission. Of course, this would not result in nearly as much monopolization as under IP laws, as contracts cannot bind non-signatories. However, some argue that there is a way to make non-signatories adhere to copy protection. Murray Rothbard, for example, argues that all contracts involve a transfer of multiple rights, and all an inventor needs to do is reserve the right to reproduce the item in a contract. Since the right to copy in that particular good are still with the inventor, Nobody who buys it, observes it, or even learns of it by osmosis can justly duplicate the item, since they haven't gained the right to copy through these activities. They can only gain it by having the inventor transfer that title to them. This belief is only possible through a flawed understanding of contracts. As established, ideas are unownable, so any contract which reserves the right to copy must be, more technically, a conditional transfer of damages, and must take the form of, I hereby owe 500,000 ounces to gold to the author if I copied the book without permission, instead of, I hereby transfer a 1/4 ounce of silver to you for this book, and I hereby recognise you as the just winner in any conflict over the information in this book. As once again, no conflicts over ideas are possible. Thus, the third party who agreed to no such conditional transfer is still allowed to make use of the information he learns of by way of osmosis or observation on his own property. Let us now critique the various forms of IP with what we have learned. Copyrights, that is, an exclusive right over the expression of original works, and patents, that is, the exclusive rights over the manufacture, sale and use of inventions, may still be possible through contracts, which can be elaborate and complex, but third parties not privy to these contracts are free to use the information however they see fit. Trade secrets, that is, a piece of information which gives its holder a competitive advantage so long as it remains secret, could be protected in a similar manner. But once again, a company could not impose an injunction to prevent non-signatories from using the information. Finally, trademarks, that is, a right to exclude competitors from using confusingly similar identifications for their goods and services, are only useful insofar as they protect the rights of consumers, as the trademark infringer misleads the customer into thinking that they are buying a certain kind of product that they are not selling. But it's difficult to see how the registrar of the trademark has had their rights violated, as they can still use the brand. We thus see that intellectual property is based upon a foundation of aggression, and those of us concerned with liberty should reassert the primacy of property rights in our bodies and our scarce resources.